Welcome to our weekly immigration show. My name is Ranchod and I represent clients throughout the 50 states because I'm an immigration attorney. And if you haven't already, smash the like button because we want to make sure that videos like this are seen by people like you so that you can continue to stay informed. Now, more importantly, today we're going to be talking about the I-601A waiver and a particular type of hardship that may be often overlooked. So you'll want to stay tuned because when you're preparing these hardship waiver arguments, it's really important to make as many as possible. And sometimes you may not be aware of all of your hardships. So this is going to be a very interesting topic for you. So let's back up here and talk about how do you qualify for the I-601A waiver. So first of all, it is taking over 3 years, depending upon the service center, just for the I-601A waiver to get approved. We're hoping that the processing times are going to come down because this administration has indicated they're trying to decrease processing times. With COVID, everything has taken longer and longer and longer because of the shutdowns, the reduction of staff, and also issues that just kind of culminated and hit its head during COVID. So all of these issues have increased processing times. Now, the first process is filing the I-130 petition. Once that gets approved, then it goes to the National Visa Center. The fee bills must be paid. Then you file the I-601A waiver. That's what we're going to be talking about today because that is the most difficult part of the whole entire process. And you might be wondering, well, why am I going through all this trouble? Why am I waiting all this time to file? Well, the reason is because the big positive is that it allows you to get a green card if you have unlawful presence where you entered without a visa and you've accrued unlawful presence. So if you're in this situation, I recommend you consult with an immigration attorney because every case is unique, every fact pattern is different, but that's the basics. So back to the processing times. I-601A waiver is filed, then it goes to the National Visa Center, affidavit of support. The U.S. citizen has to demonstrate that they meet the affidavit of support requirements or have a joint sponsor or meet it based on assets. And I just put out a video on some of the myths about the affidavit of support, so check that out. Now, after that, the DS-260 is completed, other documentation submitted, then a whole nother step in the process. There's the U.S. Embassy process in the final interview, and then you come in with the green card. So that outlines the process. Now let's talk about how do you qualify for the I-601A waiver. You need to demonstrate extreme hardship. So extreme hardship is a very high standard and mere separation is not enough. So you have to go above mere separation. And USCIS loves to say, oh, well, being separated doesn't qualify for extreme hardship. So you have to come back and be like, boom, well, I do have extreme hardship and this is why. And what we're going to be talking about here is a very specific type of extreme hardship. And that is the hardship of having the separation of an absentee father. And this is something that if the father is separated from their children, the impact that it could make is detrimental to the children. And we're going to talk about this in detail. So continue to stay tuned. And if you haven't already, make sure you subscribe because that way you'll continue to stay informed and get the weekly immigration updates, and subscribe and hit that notification bell. When we're talking about extreme hardship of having an absentee father, we can categorize this as a form of psychological hardship, particularly when you're married and you have young children. This is where we like to go and provide a detailed analysis of how this could affect the children. But it's really important to note that hardship to your children does not qualify as extreme hardship in and of itself because the children are not qualifying relatives. However, it is a form of indirect hardship. Let's look at the example of George. He's a Mexican citizen. George is married to Amy, and Amy is a U.S. citizen and has 3 U.S. citizen children. George is an attentive and loving father. Amy works full-time and sometimes she even works the graveyard shifts. Amy relies heavily on her husband for caretaking and taking care of the kids. And this is a very common situation in many of our cases where one person is going to work and the other person's taking care of the kids. And here I'm just talking about psychological impact, but you can even take that further and talk about financial hardship too, because there's a financial aspect as well when you're separated, when you take away that parent and then you have to have daycare. Sometimes that's not going to be affordable. But I'm getting off on a tangent here. Let's get back to the psychological impact and the story of Amy and George. So here, George must demonstrate and Amy must demonstrate that there would be hardship to Amy if Amy had to go with George to Mexico or if they were separated. We mentioned the children here. The children are not qualifying relatives for the purposes of an extreme hardship waiver for the I-601A, as I mentioned earlier. Now, a similar case to this was denied by the field district. This is not our case, but I'm talking about a separate case that was similarly denied by the Mexican field office. However, it was approved by the AAO. The AAO stands for the Administrative Appeals Office. In that case, the waiver applicant was able to demonstrate that the U.S. citizen spouse was nervous, was depressed, and was on the verge of a nervous breakdown. Now, this is the interesting part, is that the AAO also took into account the fact that the father's absence would have and the impact of that father's absence on the children. The teachers at the school reported that the young boys were absent a lot. They weren't doing well on tests or assignments. They also exhibited misbehavior as well. So in that situation, they were not eating well and they were also being rebellious. Now, this has also been backed up by studies that show that boys without a father are affected negatively. One study showed that fathers that were present in their life were performing better cognitively, socially, emotionally, basically across the board. Children who grow up with absent fathers tend to be more rebellious, have higher rates of drug abuse or addiction, have emotional problems, have increased delinquency, be aggressive, and have antisocial tendencies. So it's important to note that there's always exceptions to this rule. This is in general, and this is in the context of a hardship waiver. So if you're a single mom or single parent, this doesn't mean that your child is going to grow up to be this way. However, statistically, it's shown that this happens in the majority of cases, and it's important in the situation. So it's important to highlight this in an extreme hardship application. By looking at all of those factors I mentioned, then you can see how the separation of the father is going to negatively impact the family and the children. Now, this is where you can see that the children's hardship, as I mentioned, doesn't matter, but you can see if the children are acting this way, then it's of course going to affect the parent, because the parent is taking care, you're taking care of as a parent of your children, and if your children aren't doing well, you're going to be emotionally upset as well, because your children's behavior, for any of us who have children, know that your children's behavior does have an emotional impact on yourself. Now, particularly in males, there's a higher mortality rate, there's a higher probability to have contact with the police, leading to a risk of incarceration. So these studies have shown that poverty, lack of resources, instability in the household, lower parental engagement, and increased stress on the remaining parent account for negative consequences. So it comes to no surprise, if you have a separation between the parents, that there's going to be a huge amount of stress for that remaining parent. So basically, if the waiver is not granted, you're basically turning a two-parent home into a single-parent home if you're separated. And this is, to me, extreme hardship. Let's go back to the example of George. So here with George, if he had to go back to Mexico, then Amy would be taking care of the 3 kids all by herself. She would face increased anxiety, emotional upset, and possibly even have an emotional nervous breakdown because of all of the stress that all of a sudden is placed on her going from a 2-parent home to a single-parent home. The boys would have less stability. Their whole household will have lower income, and emotional support. Here what we like to do is funnel the children's hardship to Amy, because there's that indirect impact of the children's hardship to Amy to demonstrate that Amy is experiencing extreme hardship. What's the moral to the story of this whole video? Children should not be overlooked even though they are not a qualifying relative for the hardship waiver application. We like to discuss that indirect impact on the qualifying relative because no stone should be left unturned, and it's really important to make the best case possible to know that when you go in and have filed the case, you feel like the best case was presented. I invite you to give us a call at 916-613-3553. If you have questions, post your comments below. I want to thank you for taking the time to watch this video. You truly are amazing, and we'll see you next week. Bye.